Hi, and welcome to Divorce Hacker. I'm your host, Ann Grant. On this show, we'll have a variety of guests who've been through divorce and are experts on the topic. Whether you're thinking about a divorce, in the midst of it, or already divorced, we are here to share our stories with you in the hope that you may relate, learn, process, and overcome whatever you're experiencing in your life. Jeff Jacobson and Jennifer Winestone are LA family law attorneys that were instrumental in drafting new legislation that just went into effect. It creates a streamlined joint petition process for divorce and legal separation. We are excited to have them join us on Divorce Hacker to discuss how this new law will lead to a smoother and more collaborative process for those who are separating. Jeff has been practicing family law since 1996 and is certified as a specialist in family law by the State Bar. His family law practice focuses exclusively on consensual dispute resolution, including mediation and collaborative divorce. Jeff has been recognized by LA Magazine as a super lawyer for the last 14 years. He received a Eureka Award in 2019 from Collaborative Practice California in recognition of his contributions to the field of collaborative divorce in California. Jeff is the founder of Jacobson Family Law and Mediation, located in LA, and we are delighted to have him on the show today to talk about his work behind the scenes on one of the most important changes in the law that will lead to more collaborative uncoupling. Jennifer Winestone is the founder of Winestone Mediation, where she focuses on helping families resolve complex separation, divorce, and child custody disputes. A highly engaged leader in the dispute resolution community, Jennifer has acted as a dispute settlement officer for LA Superior Court. She has established the curriculum for the Divorce and Family Law Mediation course at USC Law School, where she currently serves as an adjunct professor. She was recently honored as recipient of the 2025 Eureka Award from Collaborative Practice California, recognizing her contribution to Senate Bill 1427, which created the new joint petition process, which we will be discussing today. Jeff and Jennifer, thank you so much for joining me today on Divorce Hacker. Today, we're going to talk about the new joint petition that just came into effect in the state of California on January 1st. Jennifer, I understand you were instrumental in coming up with the idea. Can you tell us a little bit more about that?
Sure. Well, I was an attorney in Toronto, Canada, and it's something that exists there. It's a joint application for divorce. So when I moved out here and realized that it was a form that doesn't exist, I started talking to colleagues and talking to Jeff about it, and that sort of started us on the path of why doesn't it exist and how do we bring it to be.
And Jeff, what was the arrangement for filing for divorce or legal separation before the joint petition came into effect?
So there really is only one way of filing for divorce, or there was before the joint petition, and that's your traditional petition, right? Where it's a number of questions: what's the date of marriage? What's the date of separation? There are check boxes as to custody, joint legal custody, sole legal custody, joint fiscal custody, sole fiscal custody. There are check boxes on spouse's support, attorney's fees. That's the only way you could start a divorce, right? And then the response form is almost a mirror image of the petition. Here's the problem, right? Is those forms, in my view, and I'm basically a full-time mediator now, but used to primarily litigate. Even in litigation, those forms are largely irrelevant to any substantive issues in the case. And the forms are really designed for cases that go by default, right? Where one spouse files and serves a petition, and the other spouse doesn't respond. Those check boxes are germane and very relevant to a default. But for a non-default case, it really plays no role, right? Even if a case goes to trial and it's litigated. And that was the only way to file for divorce. You also have this document called a summons, right? With big letters and bold print saying you are being sued. So about 10 years ago, when I really transitioned and became a full-time mediator, I really saw it every day, right? We would have this conversation with, the spouses that I worked with when we're ready to file for divorce, and me literally having to downplay these forms and say, these check boxes, I don't want you to worry and stress out too much about them. They're required on the forms, but we're going to do the petition and the response concurrently. They're going to be choreographed. No one needs to get served. But these are the only forms we could use, right? So I would kind of have to explain my way around them because there were so many things that every step of the way, what is the data separation? What check boxes for custody, for spousal support? Where the inception of a case and really mediation, people don't understand those concepts, nor should they have to, right? They're committed to resolving it without ever going to court and doing it in a collaborative and consensual manner. But here are these forms that are antithetical to that. So for years, for decades, that was the only form that I could use. I will mention in California, there's something called a joint petition for summary dissolution, which is a really cool process, but it really can only be used for what I'll call no-issue divorces. Marriages of under 5 years, no minor children, no support issues, and basically estates that are minimal, right? So for no-issue divorces, we have this lovely streamlined process, but almost nobody can use that. So when I say that, there's really one way for families to start a divorce action, that really was true. And in the state of California, which has been really visionary in terms of developing concepts like no-fault divorce, years ago, community property, joint custody, right? All these different concepts that California was a pioneer on. Somehow, lots of other states have a joint petition process and have ways of starting it, in a collaborative way that's consistent with the idea of resolving things and staying out of court. But California had none of that, right? So, when Jen had this idea for a joint petition, it really was something that was sorely lacking, that when we talk to a lot of our colleagues who are mediators or do a lot of collaborative divorce, we really got the same answer as, why didn't this exist 30 years ago or 40 years ago? We've been dealing with these forms for our entire careers, and there's complete disconnect.
Thanks. That's so helpful. And so you mentioned in sort of the old way of doing this, there's a summons. And in fact, in my experience, it's very disconcerting when you're serving the other party with the summons. And we want, as professionals in this field, most of us want to do this in as collaborative and cooperative way as we can. We want to set the tone. Do you think that, and have you experienced whether, in fact, using the joint petition changes the tone so that for couples embarking on this process, they're doing it in a more cooperative way?
Absolutely. I've already experienced that with cases. I had a case recently where one of the parties, we prepared the forms in December. So we prepared the forms at the end of December before these new forms had come out. And one of the parties called me up and said, I just can't understand. I'm feeling really uncomfortable signing off on anything that says you have been sued. Because if I'm ever deposed for professional reasons, for example, I'm going to have to answer a question about, have you ever been sued? Have you ever been a member of a lawsuit? And the anxiety that was triggering in that person was unnecessary in an already anxious time in their life. So, being able to say, well, now, because we waited on this, now here we are, January 2nd, we can actually do something different. And to provide that was instrumental to bringing the tone back, bringing the temperature down.
That's wonderful. Jeff?
And just the idea of a petition and a response, this idea that one person is filing for divorce and the other is responding to it, in many ways does set the tone for the entire divorce. And as a family lawyer for almost 30 years, it really doesn't matter legally who the petitioner, who the respondent is. But for people going through this process emotionally, it's a really big deal. And, there's a lot of things that have meaning like that to clients that we don't always think about as professionals. But being able to start a divorce as joint petitioner 1 and joint petitioner 2 on an equal playing field, right? I mean, even concerns about, someday, I want our kids to know that I'm the one who initiated the divorce or that you initiated the divorce, right? Not a legal issue, but something that, is very relevant to how people feel when they're getting divorced. This idea of starting a divorce on an equal playing field is really a big part of what the joint petition is about.
That makes a lot of sense. Now, you mentioned it fosters the collaborative process. Could you talk for a minute about the collaborative process and how that differs from what maybe we'll just call the traditional divorce process?
Sure. So these days, my practice, probably about 95% of it is serving as a mediator. The other 5% is doing, a process called collaborative divorce. And I think what both processes share when people start them at the inception is there's a commitment to resolving things on their own, to really controlling their own destiny and not leaving it to judges and strangers and custody evaluators and other people to make decisions for both of them, right? So inherent in mediation, collaborative divorce is this idea that, it's going to be their agreement, that they're going to work it out on their own. Um, so it's really a really big part of those processes and kind of tying that back with the joint petition. If you look at California law 30 years ago, right, there was something enacted in the civil code that basically says that the state of California encourages settlement and discourages people from going to court and litigating. The problem is in family law, the processes and forms complete disconnect with that concept, right? Going back to what the traditional petition response does, and the fact that there's no other options. So someone wants to file for divorce, the traditional way, and prior to January 1, 2026, there's really no other way of doing it. The idea of opening up an envelope, seeing in big letters, you are being sued, seeing these various check boxes, sole legal, sole physical custody requested, which again, unless it goes by default, in my opinion, legally mean nothing, but so meaningful for people, and the idea of, mediation or collaborative divorce, a consensual process, people starting on an equal playing field. There really was no process option to begin a divorce in a way that was consistent with that.
Right. It feels like a very significant change. So, Jennifer, let's say, and I understand that this is really well suited for the collaborative process and mediation, but let's say there are parties that or spouses that, for whatever reason, have chosen not to go down that path and are going down the more traditional path. Is there a way for them to also use the joint petition so that they too can set the tone to be more cooperative?
So if they've already started down a path, no, because this is really a process which is a starting point. So it's how we start. Um, anyone can use the joint petition form. So it's not just for people who have decided they want to mediate or decided they want to litigate. It's really setting the stage for here's what we'd like to see happen. Ideally we are going to commit to trying to reach an agreement, commit to self-determination and making these decisions ourselves, and commit to a less threatening start of a process. So it really sets the stage. The process is designed to be protective, to allow for parties who make that early commitment, who maybe can't reach resolution and require the remedy of the court at some point, to be able to exit out of the process seamlessly. So most of the code provisions that are built around the joint petition are built around the exit plan. What do we do when we need the off-ramp, in order to make that as seamless as possible?
And Jeff, what is the off ramp that Jennifer just mentioned? So let's say they start out, they think they can go down this path together. For whatever reason, they realize as they're moving down the path that they can't. Could you talk to us about what the remedy is in that situation?
Sure. So if a couple starts a joint petition process, right, the objective is to resolve it through, a full agreement called a stipulated judgment. And that's the terms of their divorce, right? Their agreement and has the same legal effect as if a judge made those orders. Difference is created by them as opposed to being imposed on them by a judge. If they don't reach an agreement, very easy for them to get into a traditional process, right? So there's a form called Notice of Revocation of Joint Petition. Doesn't revoke the entire case, but it transitions it into that traditional adversarial process where they're free to, go to court, file a request for trial setting, request for orders, everything they would be able to otherwise do. It's a very simple way to get off. So I think, as Jen was saying, the biggest challenge that we had when we developed these concepts was how do we do it in such a way where all the protections continue, where nobody has to put themselves at risk or make any sacrifices by virtue of starting, a joint petition process. So everything from automatic temporary restraining orders, right, which go into effect every time someone files for divorce, nothing has changed with a joint petition. We have those same rules in place, the same protections. Disclosure requirements, nothing changes with a joint petition, right? Jurisdictional issues involving children, nothing changes with a joint petition. And that was really our biggest challenge, is creating a process where all those protections are still in place, with the idea that, in the event that people don't resolve it through mediation or other collaborative process, how can we make sure that nobody has waived any rights, that nobody has created risk for themselves? And that was, and frankly, that was the biggest challenge. We were putting together this, and ultimately, once we were working with legislators and people in Sacramento, is answering those questions. And we're very confident that the new process does provide all those protections for people.
And the only thing I would add to that is it also starts the clock. So in California, there's an automatic 6-month waiting period before parties are eligible for divorce. And in these collaborative and mediation cases, sometimes we'll have parties who are so triggered by the traditional forms that they'll actually wait to file, in which case they're disadvantaged in that they have to wait out the clock once they're ready, once they have an agreement. So this allows people to start the clock, start the case, and in the event they transition out, they're not resetting anything. It all just continues to toll.
Got it. And so it's less expensive too. Like, for example, in the traditional way of doing this, each party had to file a filing fee to get their case initiated with the court. But in this instance, you'd only have the one filing fee, right?
Well, so that's something that was a bit of a surprise to us as well. So we did not take any position. As far as we know now, the filing fee, it's a one filing fee for the joint petition, at least in Los Angeles County. Each county may set different requirements with respect to the fees. But currently, yes, it appears that it's one filing fee for the joint petition.
And we got that question a lot, is what did we envision as far as, is it a standard $435 single filing fee or an $870 joint filing fee? And there's one question where Jen and I were totally neutral on it. And we said, that's really something that's up to the counties. Now, we had assumed that would be the, double $870 filing fee, exact same as if someone filed a petition and a response. And we were somewhat surprised when this rolled out a few weeks ago, and we saw it was only one $435 filing fee. That might change, but it was interesting because that was the one thing as we were developing this that we literally said, we have no answer on that. That's up to the counties. We didn't necessarily tend that it was a less expensive process to begin with one filing fee. That's a nice byproduct. Right after the first of the year, there was an LA Times article that talked about new laws in effect in California. And there's a little article that talked about the joint petition. And one of the things that was emphasized in that article is that's a less expensive process. right? So Jen and I are reading this in the LA Times for the first time and saying, wow, that's one filing fee. That's not necessarily something that we intended. It was a very flattering article. It wasn't necessarily what, we think should have been focused on. But the focus in the LA Times article is this is a wonderful, streamlined, and less expensive way for people to get divorced. And that wasn't necessarily something that we intended.
How wonderful.
Sure.
Now, what if someone comes to me? I'm an attorney. I practice collaboratively, but most of my work is like the traditional route. And they come to me and they say, hey, we've heard about, we read this LA Times article. I really want to use the joint petition. My husband and I, it's not contentious. We don't want it to be, but I really want you to be my lawyer. I really feel like I need to have representation and know that I can talk to you confidentially about, what is the best way through this just for me. Can she hire me and can he go hire a lawyer? And they're not going down the collaborative path. They haven't hired me as a mediator, but they're signaling to each other through the filing of the joint petition that they do want to work together and yet still have representation.
Absolutely. And there's a place on the forms for the joint petitioner one's attorney to sign on and joint petitioner two's attorney to sign on. So there's no requirement that this be done in the collaborative process. There's no requirement that people are self-represented if they're proceeding with the joint petition. Everything proceeds exactly as the traditional process, except for these very important distinctions, which is the commitment to try to get to resolution and the lack of requirements to make legal decisions before parties really understand the laws or have talked to attorneys like yourself in a comprehensive way to really go through the case and know what their positioning will be in terms of something like date of separation or spousal support. So they get to start the case before going down that road or making those decisions early.
So it sounds like there's really no downside or any instance that I can think of where you wouldn't want to adopt the joint petition. Am I wrong, or what are your thoughts on it?
It's good hearing that because that was definitely our goal, right? I mean, there's clear demographic of people who should not be using the joint petition, right? One demographic are, cases where there's a domestic violence component. I don't think they should use the joint petition. Cases where people know that they seriously disagree on issues and it's likely that litigation is going to ensue, I don't think the joint petition is a great fit. But I think for most people who really intend to resolve things without going to court, right? Again, very easy off-ramp, very easy to get into the traditional process after you filed a joint petition. And, like we said, all the protections are there. But that really is how we looked at it, is why shouldn't more people be doing this? Anybody who intends to resolve issues without going to court, why shouldn't they start their process with this streamlined joint petition process? And that's really a question we asked. Another thing I just want to add is within the joint petition process, people can also send out formal discovery, right? Whether or not attorneys are involved, all of that, information seeking, informally or formally, all of that can be done through the joint petition process. People will stay in the joint petition process until they literally seek judicial intervention, right? Filing a motion or filing a request for order or filing a request for trial setting. That's when you need to get out of the joint petition process, when you're asking a judge to make orders, to make decisions for you. But everything else, including information gathering, formal discovery, all of that can be done within the joint petition process.
Thanks for clarifying that. You probably need to be speaking to lots of family law attorneys in LA County so they understand, because when I first heard about it, it wasn't entirely clear to me whether the last scenario I discussed with you was available. So that's so helpful to know. So let's talk for a moment about the point in the process where the parties are exchanging financial information. Amongst us professionals, we call these the preliminary financial preliminary disclosures. Are they able to just exchange or work together on one set of forms? Because often when I'm working on a collaborative matter or a mediation, as a practical matter, they're working together on their forms, and it's almost redundant for them to have to do two separate schedules of assets and debts. So, does this shortcut that process as well?
No, not at this time. Nothing else has changed. There is a distinction in that we haven't seen brand new forms for the whole package for a divorce come into be. So what you will see is there will still be two separate declarations of disclosure, and they are the old forms or the traditional forms. So the boxes to fill in party information still say petitioner and respondent, but the joint petition process and the law is very clear that we're using these boxes for administrative purposes only because we don't have a whole new set of forms.
Is that something that, Jennifer, you would foresee as another adjustment that could be made that might streamline the process?
I think possibly, and you may disagree or have a different thought on this, but possibly down the road, we may see a joint schedule of assets and debts if there's no disagreement as to values or to assets or characterization of assets. But that's not something that was part of the joint petition process or is part of the joint petition process now or was part of the scope of this project.
And your question about joint disclosure is a really good one. And we did field that question from a number of professionals when we were developing all of this. And the reason why, we really didn't, advocate for there being joint disclosures really goes back to that question about protections for people. Declarations of disclosures are signed by people under penalty of perjury, right? So practically, right, a schedule of assets and debts, for example, in many cases, there's no reason why people can't work on those together, right? Oftentimes, the information is the same. They're mirror images of each other. They still need to sign a form, individually that I declare under penalty of perjury, this information is correct. So they both need to sign those. But practically, they can work on those things together, right? The income expense declarations are a little more individual specific. But going back to mediation, collaborative divorce, we always encourage people to, work on these things together. But in terms of why there isn't, a joint disclosure at this point, I think the balance with the protections and particularly what happens, right? If they don't resolve this through mediation, collaborative, or any negotiated settlement for that matter, if they don't, I think it would be problematic if they're, both signing the same thing under penalty of perjury. I can see that being problematic down the road. So at some point, this is definitely something that can be discussed in the future. But again, that kind of balance between creating a process where people work together, but also keeping all the protections in place so no one is ever going to waive any legal rights when they're starting a joint petition process.
That makes sense. So, Jeff, I know that already you've also been using this in your practice. Tell us what you've seen with the folks that you're working with and how you're seeing it. I know it's early days, but how you're seeing it play out and whether it's, you're seeing what you hoped you would see.
So the answer is yes. And based on a very small sample size, clients love it, right? I had several mediation clients who, started in the second part of last year who wanted to wait until the joint petition came out because it just felt right to them to do it that way. It's really streamlined and really simple. It's very easy to fill out. There are not any decisions to make or check boxes or anything like that. It's literally just a pre-printed list of issues that, the parties are going to resolve, things that, inclusive of pretty much everything. People don't need to make decisions. It starts a case. It effectuates service on both of them once it's filed with the court. They both appear, right? So the same legal effect as a petition and a response. The 6-month clock, jurisdictional clock to get divorced starts ticking. And people love it because of the simplicity, but also it really hits with a lot of people where, this joint petitioner 1, joint petitioner 2, just taking away those labels of somebody initiating a divorce and the other responding to the person who's initiating the divorce. It's a big deal. So far we've gotten, pretty positive reviews from clients.
That's amazing.
Yeah.
So if you were to further adjust the law, can either of you think of anything else that you would want to in the future see to further making this process as easy as possible for the people that we serve?
That's a very good question. I think we've talked about it as well. Like, where do we go from here? Because this is a really good starting point. Um, I'm not sure. I'm not sure where we go from here. There is one little tweak that I think we both agree we would make to the form, the final version of the form. I know Jeff in particular has that. We've talked about this quite a lot. But there is one little thing on the form that, in a new revision of the forms, we'd like to take it out or tweak the language on.
Yeah. And we're already working on it, by the way. It's one thing for the law to be enacted as it was in August of 2024. So we have new family code sections that are specific to the joint petition. And then after that, there was the process of the Judicial Council in Sacramento developing these forms. And Jen and I and some others really played a major role in terms of, amending the initial drafts and modifying. And we're really pleased with the final product, but it isn't necessarily where the Judicial Council started with. So we put in a lot of work last year to make sure the forms really were consistent with what we envisioned as far as what this would do. There is one line in the joint petition form that says, don't use this form if you disagree on any legal issues. And it was kind of a last minute addition. We're working on fixing it. But in our view, it's very inconsistent with everything we're doing here. When somebody files for divorce and they're just starting, a case, they shouldn't have to be making legal decisions. And it's a big part of what this is about. So in our view, that was a mistake. It's one line. It doesn't legally change any of this. But Jen looked at me when he asked that question because she knows that drives me crazy because I want these forms to be perfect. And it is something that I would, kind of consider a mistake. So we're working on fixing that. Back to your question, Anne, what else would we change? Well, when we went through this, we looked at a lot of different forms. And almost every form in this catalog of family law forms in California, and there's a ton of them, almost all of them are geared toward litigation and designed for litigation. The reality is most people resolve their cases without going to trial. So this idea of people reaching an agreement and filing it with the court, we always kind of felt that the forms were subpar in terms of, being specific to that as opposed to these general same forms you would use if it were, a litigated judgment that someone was filing with the court. So at some point in our lives, will there be an overhaul of those forms that really adapt to the reality that most people resolve their divorces without ever stepping foot, in a courtroom? We hope so. And I'll just kind of give you one example of it. When people have an agreement, a stipulated judgment that they file with the court, there's a form and you have a choice of, did it go by default or was it uncontested? Right. So the kind of mediated or collaborative divorces and certainly under the joint petition, they're not going by default. But then there's this weird word uncontested. And Jen and I scanned the family code to see, where there references this term uncontested and didn't really find anything. So I still don't know what that means. Replace the word uncontested with mutually agreed upon, because that's what this is. Yeah. And it just, in many ways highlighted what I started with, this utter and complete disconnect between the policies of the state to encourage people to resolve things without going to court and the processes and forms. So joint petition is a big part of that, but there's still, this other catalog of forms that really needs to get up to speed with the same concepts.
Yeah, so building out the infrastructure to support the policies that already exist and the practices that already exist. But this is a starting point.
Yeah, it's a great starting point. Thank you both so much. You answered a lot of questions that I had after looking at the new forms and the note that you made about my last question and the hangovers maybe from the prior forms raise questions for me that you've clarified. And I really appreciate that and really appreciate the work and the service that you put into this to bring this into being because I think it will really change the tone of starting the case, which for many, many people, and for those of us who practice in this area, we know is so very important. So thank you so much for joining me today.
Thank you for having us.